Hello friends, in today's session let's discuss about collective mark. So when we talk about collective mark, we need to look into the chapter 8 of the Trademarks Act 1999 and the corresponding sections to them is section 61 to 68. Now when we talk about collective mark, we need to understand that these are the marks, these are the trademarks which are owned by the collective. For example, the CA Institute or the CPA certified professional. So they are all the collective marks. They represents a group of people, a group of members, so which have a particular qualification or which are governed under certain regulations. So all these marks which represent a particular organization, particular set of people, they all are known as the collective mark. The Bar Council of India, the BCI. So BCI represents the advocates, collective union of the advocates. So that is again a collective mark. So when we apply for the mark, for the collective mark, we need to understand that the application is slightly different, not much different, but slightly different from what the original the normal application for the trademark is. So the application part starts from section 63. So what 63 states is that whenever you apply for the registration of a collective mark, it should be accompanied with the governing regulations. So these governing regulations are the regulations of the organization for which the mark represents. Each organization, when it is set up, it do have some certain governing regulations. So these regulations have to be presented before the registrar of the trademarks whenever you apply for the registration. Post this application is then moved for the acceptance of the application, and this can be unconditional as well as conditional acceptance. So the registrar may accept it conditionally or may impose certain conditions for accepting the particular mark. Along with the application, the regulations are also subjected to the acceptance or rejection by the registrar. So if there is an acceptance to the application, then the regulations will have to also to be accepted. Otherwise, the registrar may ask you to amend the regulations as well if he finds any ambiguity with the registration, with the regulations. This is covered under section 64. Now, when we talk about the regulations, then these regulations are always subject to the public inspection, same as what we have for section 49, section 148. Everything is open for the public inspection. So this is covered under section 65. Now, moving ahead, whenever we move for any of the amendments to the regulation, so during the course of the business, during the course of management of the particular organization, you might need to amend the regulations. So in all such cases, when there is an amendment to the regulation, you need to first provide the amended regulations to the registrar. These regulations will only have effect when they are provided to the registrar and registrar approves those regulations. If the regulations are not approved by the registrar, then it would not be there for the it would not have any effect for that particular mark. Now, coming towards the infringement proceedings. So whenever there is an infringement proceeding, all the authorized users or all the members of the particular organization for which the collective mark represents have to be taken into account. So interest of all the authorized users have to be taken into account whenever we talk about any infringement proceeding. So that particular organization for which has got the collective mark registered into its name, that can again move for the infringement proceedings against any of the non-user of or the unauthorized user of that particular mark. So in that case also, the interest of all the authorized users have to be taken into account. Now when we talk about grounds for removal of a collective mark, so all those grounds which were earlier for the normal mark, they remain the same for the collective mark as well. So all grounds under section 47, that is the non-bona fide use. If you have non-bona fide use, or you are not using that particular mark for the particular set of products. For example, you have got your mark registered under class 5 and you are using that particular mark for class 6. So that becomes one of the ground for removal, if you remember, under section 47. So that again is a ground for removal for collective mark again. And Second, not used for continuous period of 5 years. So, for example, you have got a mark registered, but you have not used from the date of application. You have not used that mark for a continuous period of 5 years. That has to be a continuous period. If in between you have used that mark and then left, that breaks the period of 5 years. But if you have not used it for a continuous period of 5 years, then that again becomes a ground for revocation of the mark. Apart from it, section 68 gives certain additional grounds for the removal of the collective mark. The first ground which section 68 gives is that the mark is misleading to the public. So there is a public deception. In cases of deception, again the marks get revoked. So that goes for the collective mark as well. So if there is a misleading mark and which creates a deception in the minds of the people, that is again a ground for removal. And the last ground for the removal of the collective mark is that the governing regulations which were submitted at the time of getting the mark registered are not observed or are not followed, or anything contrary to those regulations have taken place, then again that becomes a ground for removal of the collective mark. I hope you all liked this video. If you have any doubt, you can always drop them in the comment section below. Please do hit the like button and subscribe my channel. Thank you.